the Duke Human Rights Initiative, and the GDLM program. So thank you to all of them. The panel involves Joe Neff of the Raleigh News Observer, Professor Silliman of Duke, Doug Brooks of the IPA, and Frank Fountain. And it will be moderated by Professor Morris. Professor Morris, as you guys probably know, is the professor of law here at Duke University. She serves as advisor to the Chief Defense Counsel for the detainees at Guantanamo in their proceedings before the U.S. military commissions, the U.S. Department of Defense, and directs the Guantanamo Defense Clinic, which I presume some of you guys are in. She has served as senior legal counsel for the Office of the Prosecutor at the Special Court for Sierra Leone, has provided consultation to the State Department in the Office of War Crimes, and has served as an advisor on justice to the President of Rwanda. She is a member of the advisory board of the American Bar Association Central and Eastern European Law Initiative and a member of the board of advisors of the Center on Law, Ethics, and National Security here at Duke. She teaches public international law, international human rights, and international criminal law, and has published widely in all of those fields, and I'm sure you guys know her, so I'm going to hand it over to her right now.
It's a pleasure for me to have the opportunity to moderate this panel and to share with you the deep knowledge of those on the panel and the developing deep thoughts that you would have, I'm sure, on this issue. It's an issue that's come more and more to the fore, as you know. Going from a period and a history in which there was a much deeper and clearer black line divide between military forces as state actors and defense contractors as private sort of support and associated corporations and organizations. We've now gone, as you know and as you hear daily in the news, to a situation where those lines are much more porous, and the participation of private actors in military operations, both combat-specific and peacekeeping, have emerged as very important and very contentious part of our current international scene. Certainly, there are advantages and disadvantages, or at the very least, there are views to that effect, which we will hear aired and hopefully not erred, and gone into in about 10 minutes presentation by each of our panelists, and leaving therefore a great deal of time for discussion. Pleased to have all of you here, faculty, students, people from other parts of the university, people from media, and of course, our guests. What I'm going to do is to introduce each panelist just before they speak so that you'll really have a sense and a recollection by the time that we get from presentation to presentation about who we're hearing from. The first person that we will hear from is Joe Neff, who is an investigative reporter at the News and Observer in Raleigh. He began working as a reporter in 1989 at the Associated Press in New York, where he covered breaking news and federal courts for AP, and then moved from there to the NNO. He's covered prison, police, courts, and legislative developments, was a Knight Fellow at Stanford University, and since his return from California has continued his work as an investigative reporter. Native of Cleveland, Joseph holds a BA in American Culture from Northwestern, a master's in International Affairs from Columbia, and was a Peace Corps volunteer in Ghana, where he taught beekeeping. He's married with 2 children and lives in Durham. Welcome.
Thank you for having me here today. Unlike the other panelists, I am not an expert. I'm a reporter. I dip in and out of issues and stories, and I'm here today because a colleague and I wrote a series of stories that squarely deals with today's topic. If you picked up the paper or turned on the television on April 1st, 2004, you couldn't miss the image of the bodies of 4 American contractors dragged through the streets of Fallujah, set on fire, and several of them hanging from a green steel bridge with crowds of Iraqis celebrating this. We wrote a story, a colleague and I, about these 4 men who were killed, about the company who they worked for, Blackwater, and about the military and the lessons that we could glean from this. You can find, the series is still on the web if you go to newsobserver.com, keyword The Bridge. It's all there. One of the big issues that we came across in the series was who's in charge of the battlefield. In mid-March 2004, the Marines took over command of the El Anbar province where Fallujah is. They took over from the 82nd Airborne. And the Marines had this tough love plan to try to pacify the area. They had about $500 million for rebuilding and projects and walk-around money. Almost all the Marines had taken classes in rudimentary Arabic. They learned how to greet people, how to be respectful, when to take your sunglasses off, how to deal with old people versus young people. And they had the rudiments to be culturally sensitive on the battlefield. But they also came with their helicopters and attack helicopters and their weapons, and they were prepared to go after the bad guys. It was a carrot and stick approach. And in the run-up to the incident I'm going to talk about, Iraq was really, really heating up. Israel had recently killed the head of Hamas. The U.S. military had shut down the newspaper of Muqtada al-Sadr. There were several attacks on the Marines in this area, killing a few of them. And Fallujah was not a place to go at that time. The Marines, when they went into Fallujah, would only go in force armored vehicles with lots of weapons. And so they had this plan on they were trying to take control over and calm down this area. Those plans went up in smoke on that bridge in Fallujah. These 4 contractors were escorting a convoy of 3 empty trucks to go pick up food equipment for the military. The contractors drove in unarmored SUVs that my colleague who spent some time in Fallujah said were known as bullet magnets. The Marines had no idea that day that the contractors were going through Fallujah. They learned about it on Fox News. Months of preparation and planning were destroyed in an instant. After these images, these mutilated bodies were shown around the world, Paul Bremer, the head of the CPA, vowed that these deaths will not go unpunished. General Kimmett said that we will pacify this city, and so did President Bush's spokesman. So the Marines were ordered in, and they did what they're good at. They went in and they broke things and they killed people. They pounded the city and they started taking it over block by block. This wasn't in their plans, but that's were their orders. Halfway through, Washington ordered them out, stopped the attack. So the Marines pulled out. They were ordered into a battle they didn't want. They were ordered out before they finished the job, and Fallujah became a terrorist enclave until the Marines returned in November, where they took the city, and large parts of it are still in rubble today. Now, Blackwater, these 4 contractors didn't cause everything that's going on in Iraq, but they certainly triggered that conflagration. And the question is, shouldn't the military know and control the movement of private contractors on the battlefield? Shouldn't a battlefield commander command his battlefield? Second question that brought up was, who holds the contractors accountable? In this, I was really stunned to find out that the military didn't conduct an investigation on what happened in Fallujah, and neither did the CPA, the Coalition Provisional Authority. It's because these are private contractors. They're not. So neither of these entities investigated. Blackwater investigated, but they did not release their investigation. In the course of reporting, we obtained some documents showing how Blackwater, as it was going into the city, violated its very own rules, the terms of its contract. They were supposed to have 3 men in the vehicle. It makes sense. You got 1 guy driving, and you need 2 people to be able to keep a 360-degree lookout. Well, they went in with a driver and 1 guy, so it was in each car, and 1 person can't keep scanning 360 degrees. So it was very easy when they were stuck in traffic for the gunman to pop out and sneak up behind him and shoot him just like that. They were supposed to have armored vehicles. They didn't. And they were supposed to have advanced intelligence about where they were going that day, and they didn't. Military officers told us that had a Marine officer or an Army officer ordered troops into Fallujah, 2 in a car, unarmored, no intelligence, no backup, that officer would be court-martialed. But these are civilians, and they're not covered by military law. The families of these men wanted to know what happened, and they have gotten no answer from Blackwater. So they have one remedy. They're suing in civil court. They filed a lawsuit about 15 months ago. And here in North Carolina, here in the next county over, Wake County Court, there's a lawsuit going on, which is a big, for the families, it's a big uphill struggle for them to get answers. The other point that came up in terms of holding people accountable, we have thousands of private military contractors in Iraq. I don't, Doug might know, 10, 20, 30,000. I don't know how many, but there's a lot. And as of this day, I do not know, have not read, or do not know of a single time when when a private military contractor has been prosecuted in Iraq or in their home country. I mean, Doug may know, he's probably got more current information, but they fall into a legal crack. They're not subject to military justice. The Iraqi justice system is not prosecuting anyone, and they're not being prosecuted at home. Now, I know that the vast overwhelming majority of private military contractors are obeying the rules and not breaking laws, but imagine if you had a city of 25,000 men, alpha males, in stressful conditions, lawless, chaotic, all with weapons, and no crimes have been committed. That's impossible for me to believe. The Army, the military, has court-martialed hundreds of soldiers in Iraq from charges ranging from illegal use of alcohol to murder. The final point I'd like to make is a fiscal one. What are we, the taxpayers, paying? And what are we getting in return? And like everything else about this story, I found it to be murky and obscured. The Blackwater was operating under cost-plus contract. Ultimately, it's Halliburton who's the lead contractor on this. They get reimbursed for their costs, plus a small percentage on top for profit. Now, in this situation, the 4 guys who got killed, I'll start with one of them. His name was Jerry Zofko, and he grew up in Cleveland, where I grew up. And he worked then for Blackwater. Blackwater then worked for Regency Hotels of Kuwait. Regency Hotels worked for ESS, a European food company. ESS worked for Halliburton. Halliburton works for the U.S. military and us, the taxpayers. So here's how these 5 layers of contract work. Jerry Zofko got paid $600 a day. Blackwater marked that up to $815 a day. Plus, Blackwater was paid for room, board, transport, insurance, weapons, ammunitions, vehicles, office overhead, taxes, duties, the whole enchilada they were reimbursed for. Then Regency, which is basically a small company, a Kuwaiti sheik and a retired U.S. Army officer, it was a pass-through. To operate in Kuwait, you had to have a Kuwaiti company involved. So went through Regency. They got to tack on their overhead and profit. And then it went through ESS, and they got to tack on their overhead and profit. And then Halliburton submits all of those costs to the U.S. government and adds on their little bit of profit. So Jerry Zofko's out there working for $600 a day. The question we could not get answered was, what is the final cost to us, the taxpayer? Is this doubled, tripled, quadrupled? I don't know. That question you think could be something that'd be answered by the Defense Contract Audit Agency, but they were having a hard time just getting the documentation from Halliburton. At one point, they out of a $4 billion bill that was submitted, Halliburton, or the auditors said, we don't have the documentation for $1.8 billion on this. How can we reimburse you for this? The auditors recommended not paying it, withholding some of the payments as a stick to get better accounting in place. But the auditors only have an advisory role, so the Army Field Support Command, different branch of the military, made the decision, overruled them, and paid them with bonuses. You'd think that Congress could get an answer. Well, this is the most recent audit that Congress has gotten from the Defense Contract Audit Agency regarding this Halliburton contract, which ultimately the Blackwater contractors were working under. And here's a ledger sheet. This is what Congress is getting. Here is the bit about how does the purchasing system work. I get frustrated by this as a reporter, not being able to get information, but this is what Congress is getting on this. One of the people I talked to is for the story is a guy named Henry Bunting, a former Halliburton purchasing officer, and he told me he heard a common refrain in Kuwait when he was working there for the KBR, the branch of Halliburton. He said the common refrain went like this: "Don't worry about prices, it's cost plus." He said there is no question the taxpayer is getting screwed. There is no incentive for Halliburton or their subs to try to reduce costs. No matter what it costs, Halliburton gets 100% back plus their profit. And Halliburton won't discuss their spending. Won't discuss their spending, let alone the spending of the subcontractors and the sub-subcontractors, and in the case we have here, the sub-sub-subcontractors. The other really interesting thing that I found here was that usually reporters, we develop sources or whistleblowers who help us in doing stories. But in this case, the contract that Jerry Zovko signed with Blackwater signs away his rights to sue. Makes everything, he can't sue, I don't know. Basically, he just can't sue. And if he was to break the terms of his contract, there was a clause in there that he would immediately pay Blackwater $250,000 in liquidated damages within 3 business days. So if he actually went out and talked about they're breaking the rules or they're overcharging or anything, bingo. You signed a contract to fork up $250,000 in 3 business days. And that is I imagine, a major disincentive to talking to anyone, whether in Congress or the likes of me.
I can imagine it is. Has anybody tried to identify Blackwater as an agent of the U.S. government and therefore bring a First Amendment objection to the would-be gag order? Not to your knowledge.
No.
Next, our own Scott Silliman, who joined the faculty here at Duke in September of 1993. He's a professor of the practice of law here at Duke, as well as the executive director of the Law School's Center on Law, Ethics, and National Security. He also holds appointments as an adjunct professor of law at the University of North Carolina at Chapel Hill and at North Carolina Central. Professor Silliman received his BA in philosophy in 1965 and a JD in '68 from the University of North Carolina at Chapel Hill. Participated in a 4-year Air Force ROTC program and was called to active duty as an Air Force judge advocate in 1968. During his career as a military attorney, he held a variety of leadership positions, including staff judge advocate, which is the senior attorney, at 2 large installations and 3 major Air Force commands. In his last assignment as the senior attorney for Tactical Air Command and later Air Combat Command, he was general counsel to the commander of the largest principal organization within the Air Force, with 185,000 military and civilian personnel at 46 primary locations throughout the world. In this capacity, he managed a command law firm of 715 active duty and reserve lawyers, paralegals, and civilian support staff. During the Persian Gulf War, he supervised the deployment of all Air Force attorneys and paralegals incident to Operations Desert Shield and Desert Storm. After 25 years of service, in 1993, he retired from the Air Force as a colonel to assume his position here at Duke. His teaching and research interests focus on national security law, international humanitarian law, and operational law. He's been widely and increasingly sought throughout the United States as a guest lecturer and a frequent commentator on CNN, NPR, and other radio, newspaper, and television networks. He has, for many years now, put together and directed the annual Law, Ethics, and National Security Conference here at Duke, which has become widely known as a major annual event in the field. And we thank him for being here at Duke and on this panel. Thank you, Scott.
Thank you, Madeline. Let me try and put this whole issue of private contractors into a little bit of perspective for us. This did not start after the United States went into Afghanistan. Actually, it goes back to the beginning of the Bush administration, when Secretary of Defense Rumsfeld decided that he wanted to change what's called the tooth-to-tail relationship, which is the warfighting capacity, the trigger pullers, as they say, and the support function. And if you can contract out some of the support functions like feeding the troops, transportation, even security, then you can take those same positions and make them uniform positions and put them up on the front line. So this really went all the way back many, many years. But as Joe has already mentioned, early on there were questions, is it cost effective? When you're paying someone $600 or $800 per day to do the job that a private or a sergeant's doing for, I should suggest, a whole lot less pay, then is it cost effective, and who's really making the money from your taxpayers' dollars? So cost efficiency has always been a big issue, and I think Joe and his colleagues in the press have done us a service in raising this. I think a more fundamental problem, though, is what's called the span of control. A military commander, and Joe mentioned this, has absolute authority over those in uniform, and he can subject them to disciplinary punishment, including criminal prosecution, if they fail to obey his orders to do something. You can't do that with a civilian contractor. You just can't do it. Just a second, I'll come to the legal framework for how civilian contractors fit in. But span of control is something that very candidly drives military commanders crazy. And what happened at Fallujah was an excellent example. Military commanders not even knowing which civilian contractors are in the area, let alone what they're doing. The last thing is what we call interoperability. If you've got civilian contractors on the battlefield, generally speaking, they can't even communicate with the uniformed troops. And not only that, but the systems that they employ, whether it be helicopters, weapon systems, are generally different. So you've got a mixture of different types of equipment, one being used by contractors, the other by military. It creates a nightmare as far as the efficiency of warfighting. So all those are problems that should have been recognized early on. The program was rushed into being under the tooth-to-tail change rationale, and now I think we're starting to see some of the problems. But let me do this. Let me kind of show you what the legal framework is as to with regard to these private contractors. Joe already mentioned that they are not subject to the Uniform Code of Military Justice, which is the criminal code that governs all military members. Now, arguably, there are two sections of the Uniform Code of Military Justice that could apply. One says that in time of war, there is court-martial jurisdiction over those accompanying the forces of the Army in the field. That's what we call Article A2A10. But in time of war has been declared by at least one court and not been overturned as meaning in a time of declared war. I think you know when the last declared war was in this country. It was World War II. So for the last 55 years, that has not been available. The other provision is that says that those subject to treaty agreements, those who are accompanying the forces overseas, may be prosecuted by court-martial. And that's what Congress originally set out. But in 1957, the United States Supreme Court, in the case that I know some of you have studied from my class, Reed versus Covert, set that aside as saying it's unconstitutional to take civilians, American civilians, particularly in a capital offense, and subject them to court-martial jurisdiction because their Fifth and Sixth Amendments are not totally guaranteed. So since 1957, there has been no provision for dealing with prosecuting civilians overseas when they commit offenses like abuses of detainees. So where are we? Well, Congress has started to act, and they started to act about 10 years ago. The War Crimes Act of 1996, amended in 1997, does provide for jurisdiction, criminal jurisdiction in the federal courts, not a military court-martial, in the federal courts, when there is a violation of, well, a commission of a war crime. And a war crime is defined under the War Crimes Act as a grave breach of the Geneva Conventions, a violation of what we call Common Article 3 of the Geneva Conventions, which applies in non-international conflict and criminalizes such things as inhuman and degrading treatment, torture, and also certain other treaties tied in with landmines, the Protocol on Landmines. But to my knowledge, there has not been a prosecution under the War Crimes Act because the prosecutor first of all has to show that that assault, that crime that occurred in Iraq or Afghanistan does in fact constitute a war crime under the act. But interestingly, when Congressman Jones actually created this and it was signed into law, it applies as to whenever an American citizen or a member of the military is either the victim or the prosecutor, or the persecutor, I should say, not the prosecutor, the persecutor. So whoever commits an offense or is the victim of an offense, if they're an American citizen, theoretically could be prosecuted under the War Crimes Act, including a private contractor. But again, it's untested, hasn't been used. More recently, in the year 2000, Congress passed what's called the Military Extraterritorial Jurisdiction Act. Again, it doesn't put jurisdiction in military courts-martial, which I think is what military commanders would like. It vests jurisdiction in the federal criminal courts of the United States when there is an offense which, if committed in the United States, would result in the punishment of more than 1 year. Now, originally when it was passed, it only pertained to DOD contractors and subcontractors, and so there was a limitation. There are a lot of other contractors, like those contracted by the CPA, Paul Bremer's folks. Or what about CIA contractors? They're not DOD contractors. Well, just last year, as a part of the 2005 Defense Authorization Bill, Congress expanded the jurisdiction under MIJA, Military Extraterritorial Jurisdiction Act, to include other government contractors when acting in furtherance of the Department of Defense mission. Now, I'll be honest with you, I'm not really sure I understand who that encompasses. What is acting in furtherance of the DOD mission? Presumably, Blackwater would be covered by that because they're providing security for DOD. But what about some other contractor who's a little bit more distant from the DOD mission? Again, this act has not been used, so we don't really know the full scope of the jurisdiction. You've also got the Patriot Act, which extended the definition of what we call special maritime and territorial jurisdiction. And this, by the way, is the jurisdictional predicate that's being used over here in Raleigh to prosecute a CIA contractor by the name of Frank Pizarro. You might have read about this in the papers. What it does, and I'll read you the extension, it says that the territory of the United States, for purposes of a violation of Title 18, most of the felonies, including assaults committed against a detainee when they're being interrogated, extends to this: the premises of United States diplomatic, consular, military, and other United States government missions or entities in foreign states, including the buildings, parts of buildings, and land appurtenant or ancillary thereto or used for purposes of those missions or entities, irrespective of ownership. A lot of legal language in there. What's significant is, in the first case, using this language, the one over here in Raleigh, dealing with David Pizarro, they found that basically a detention facility in Afghanistan that was provided to Pizarro, where there were also military personnel there, a rudimentary structure, was governed under this particular provision. So in theory, you could say anywhere where you got a private contractor with what's called boots on the ground, anywhere he is, anywhere in the world, could be subject to jurisdiction in the federal courts. So there is at least some legal framework for criminal prosecution of private contractors. But again, other than the Pizarro case, it's been relatively untested, and we really don't know how effective it's going to be. My guess is that Congress is not going to try to amend the Uniform Code of Military Justice to create court-martial jurisdiction, particularly after what the Supreme Court said in Reed v. Covert over 50 years ago. But is there now a closely woven fabric of criminal jurisdiction so we can hold accountable private contractors when they commit clear offenses, abuses of detainees, or something that can bring them to justice? I think there is. Even with that, though, it doesn't solve the real fundamental issue that I raised at the beginning of my comments is, what about that military commander who's charged with providing a mission to accomplish a particular goal, and he's got military personnel who he controls and private contractors he doesn't? That civil aspect of accountability is still unresolved, and I think is one of the biggest problems we've got in private contractors.
Thank you very much, Scott. When we come back to the discussion, I'm wondering whether it wouldn't, if it's possible to create the kinds of constraints that Jeff was talking about on the behavior of private contract personnel, whether it wouldn't also be able to provide some command constraints, that is to say, to provide that further control in that way as well. Our next speaker, Doug Brooks, we're very pleased to have with us. He's the president of the International Peace Operations Association, which is a nonprofit association of service companies dedicated to improving international peacekeeping efforts through greater privatization. He's a specialist on African security issues and has written extensively on the regulation and constructive utilization of private sector for international stabilization, peacekeeping, and humanitarian missions, particularly in Africa. He's testified before Congress, appeared on BBC, CBS, NBC, Fox, and many other media stations and papers.
CNN, too.
And of course, naturally, it goes without saying, or did, CNN. The Lehrer NewsHour, making Lehrer NewsHour, now Lehrer. He's lectured at numerous universities and colleges at Georgetown, South African Defense College, South African War College, the Inter-American Defense College at Fort McNair. Originally from Indiana, has a BA in history from Indiana, an MA in history from Baylor, and additional doctoral studies at the Graduate School of Public and International Affairs at Pittsburgh. He's worked as a teacher in Kambazuma, township of Harare, Zimbabwe, at the Library of Congress, National Archives, Institute of International Education, the International Management Development Institute in Pittsburgh, and was an academic fellow at the South African Institute for International Affairs, 99 to 2000. Welcome.
Great, thank you very much. Thanks for having me. I'm not a lawyer, and I'm from Indiana, so I'm a bit of a hen in the fox house here, but we'll see what I can do. First of all, true story. There's a turtle in a bird's nest, and it starts flapping its legs, and it jumps out of the bird's nest, and it crashes to the ground. And the turtle goes back to the tree, climbs up the tree again, goes back out to the nest, starts flapping its legs, jumps again, crashes to the ground. So it's doing this again and again and again. And there's two birds watching this whole thing. And one bird says to the other bird, "Frank, you think we should tell him he's adopted?" Making turtles fly is a little bit like what the UN tries to do with peacekeeping operations, where it doesn't get the support it needs. The reality of contractors in conflict and post-conflict environments, CPCs, is that we need them. Essentially, I'm going to try and do this sideways here. Any stability operation or peacekeeping operation, whether it's a U.S. military operation, a UN operation, an Africa Union operation, is going to have a large percentage of contractors providing support for that operation. So we use it for our foreign policy. Every country in the world essentially uses it, and the UN uses the private sector extensively for their operations. Why do we use the private sector? Number one is surge capacity. The reality that when a country or when an organization is trying to do a mission, they need a lot of specialized skills very quickly. And the first thing they're able to do is go to the private sector, lift up a phone. We call it the oh crap phone call because usually it happens at the last minute. It's like, oh crap, we need this kind of skill. They pick up the phone, they call a company, KBR, PAE Logistics, whatever, and say we need a bridge or we need this kind of specialty. We need load masters for helicopters, something like that. And the industry is able to provide that. Faster, better, cheaper. Essentially, when you're using these companies that work in the conflict, post-conflict environments, their personnel come from the military. They're ex-military people, people who have spent 10, 20, 30 years in the military doing operations, and they bring these skills to the private sector, which is able to provide them to the UN, to the US, or whoever else. And faster. Essentially, the private sector does everything on a 2-week framework because, as I said, it's a oh crap phone call comes in and you have 2 weeks to get off your duff and actually get a project underway. It's something that the US government is not able to do. It's something that the UN takes 8 months to do. So the private sector brings a lot of capabilities to UN and to peacekeeping and stability operations. Why would humanitarians want the private sector in peace and stability operations? We'll go into that a little bit more, but the reality is we need them. Security in any peace or stability operation is 90% of the problem, 10% of the solution. You need to have effective security. Now, whether it's provided by blue helmets, UN blue helmets, or military, or whoever, is irrelevant. But the security has to be there before you can start rebuilding states, before you can do reconciliation between communities. The NGOs, the non-governmental organizations, humanitarian organizations that are involved in Congo and so on, they can't go in the field until it's safe enough for their people to go in the field. So you need to have that security, and what this industry does is support the security. Again, whether it's UN or US military, you have private sector behind it. Westernless peacekeeping is the reality of peacekeeping today. Essentially, the West doesn't do peacekeeping anymore. The US military is a third smaller than it was in 1990. West European militaries are 50% smaller. Why does that matter? Because those are the best militaries in the world. And if you don't have West Europe, if you don't have the US taking the lead in peacekeeping operations, you end up using militaries from the poorest countries in the world. And you can imagine the results on that. The better you do a peace and stability operation, the more people will be alive at the end. And that's really got to be the bottom line, whether it's in Congo or Iraq. The better you can do the stability reconstruction, the more people will be alive at the end. Finally, I think we need to realize or keep in mind that as a private sector operation, the clients are allowed to demand accountability and transparency, and the industry has to support that. I mean, we don't write our own contracts. Somebody writes the contracts and we follow them. Just to put things in perspective, a lot of the problems that are raised about the private sector are raised because it is a private sector, because it is private actors in conflict, post-conflict environments. And I think we need to keep that in perspective. If we look in Iraq specifically, and we look at the times that there's been an escalation of force, where there's actually been shooting involving convoys and private security details and so on. Last year, there's over 3,800 escalations of force. Of that number, that's a lot. Of that number, about 5% related to the private sector. That's still a lot of escalations of force, and it's still something that we as an industry have to address and reduce that as much as possible. You're still going to have legitimate uses of force, but you want to keep it as small as possible. And let's just keep in perspective that even in Iraq, we're talking about 5% of the entire conflict. Camouflage versus blue jeans. Our belief as an industry is that whether you're wearing blue jeans in one of these areas or you're actually a military person in uniform, you should be able to be held accountable. This is something the industry supports strongly, and what was mentioned earlier was MEJA. We supported MEJA. We supported the extension of MEJA to all contractors working in support of a DoD mission. Our industry actually endorsed that. It makes sense. I mean, essentially, if your own client, the U.S. government, can't hold you accountable, they're not going to hire you. So from our perspective, we're happy to work with people to expand the rules, to make it easier to hold contractors accountable. We actually, I think in the past, before IPOA was started, the industry, our company supported the UCMJ, the use of UCMJ for civilians. There were 80,000 contractors in Vietnam, a lot more in Vietnam than there are in Iraq right now. So this issue's been there before, and we have some key issues that we need to address. In terms of regulations, a lot of people mistakenly say this is an unregulated industry, and right here's a few of the regulations that the industry has to deal with. ITAR, International Traffic and Arms Regulations. Anytime you sell a service, ship a weapon abroad or whatever, you have to get a permission, a license from the U.S. government for American companies. So FAR, Federal Acquisition Regulations, DFARS, actually it's Defense Federal Acquisitions Regulation Supplement, and DBA, Defense Base Act. There's a bunch of regulations that apply to these companies. This is a very regulated industry. It doesn't mean it can't be improved, but there are a lot of things on the book. Industry ethics. Within the industry, again, it makes sense that clients, whether it's U.S. government or the UN, can be held accountable. We have at IPOA, the International Peace Operations Association, we have our own code of conduct that was in fact written by human rights lawyers and non-governmental organizations, and the companies adopted it. We also have a standards committee to address any problems that are brought in front of us. And in part of that, by the way, we're going to create a external group of human rights people to monitor the standards committee and make sure that it's done transparently. The reality, again, of this industry is people working in this industry 90% of the time are former military themselves. They don't hang up their ethics when they leave the military after 10 or 20 years. They still have those ethics. They're not going to do anything that's going to mean they can't go home to their families and homes and so on. There's a lot of reasons for this. Some of the exaggerations you'll see kicked around are the $200 billion industry, which is probably about 10 times the actual size of the industry, but people keep throwing that number out. The 25,000 mercenaries working in Iraq, let's just winnow down that number a little bit. Of the 25,000 or so people working for Western security companies in Iraq, this is just the security now, we're not talking about logistics or anything. Of the 25,000 there, all but about 5,000, 6,000, 7,000 are actually Iraqis. And that's the way the private sector works. When they go into a country, they hire locals. And in the security industry in Iraq, you have about 18,000 Iraqis working for private sector companies. The rest, 5,000 to 7,000, are actually non-Iraqis. And that includes Americans, Brits, Australians, Chileans, Salvadorans, Nepalese, and so on. Just real quick to give you a better handle on what companies operate in conflict, post-conflict environment, sort of breaks down into 3 categories. Category on the left is the companies that provide support for peace and stability operations. That's the KBRs that we were talking about, Kellogg Brown and Roots. That's the PAE logistics. That's demining companies, medical companies, aviation companies, helicopter companies. That's 90 to 95% of the industry in money. So when we talk about maybe a $20 billion industry, 90 to 95% of it is that boring part, the first part. Second part and third part are the more interesting ones, the sexy ones, the ones that Joe pays attention to. The private security companies protect things. We say they protect a noun, a person, a place, a thing. They're hired to provide security and make sure that whatever they're protecting doesn't get killed in the operation. That's what they do. That's it. Third group there is the private military companies. And they're the ones that provide the security sector reform, the training, so that you have a long-term solution, a strategic solution to the problem. In the case of the Balkans, it involved training up the militaries in Bosnia and also Croatia to balance out the Croatians, or balance out the Serbs. And it ended the war there. In the case of Iraq, you have private companies training the police, training the military, training the border guards. Also in Congo, similar sort of thing. In Afghanistan, private companies do a lot of this sort of work. So you have those general 3 categories, but again, when you think of the industry and the size of the issue we're talking about, just keep in mind that first column there in terms of personnel, money, everything, the boring part is 90 to 95% of the numbers you see. These are a few companies taken at random. They all happen to be IPOA members. That are members of our trade association. We're about a little less than 50% security companies, but we also have aviation companies. Amoco's a construction company working in Iraq. PAE's a logistics company. The first guys on the ground in Darfur for the Africa Union peacekeeping force were in fact private guys coming through PAE, Pacific Architects and Engineers. And down here, medical support solutions. African militaries don't have their own medical corps. Where do you get it? Off the shelf. There's a private company that provides doctors, surgeons, and so on to go into conflict, post-conflict areas and do the kind of medical services required for a peacekeeping operation. What sort of alternatives do we have to the private sector? You know, we say, oh my God, we can't have private companies operating in CPC environments. Well, we really don't have a whole lot of options. The reality of peacekeeping around the world is a reluctance to support peacekeeping operations. When you start looking at the numbers as to how many people are provided to peacekeeping and stability operations, well, let's focus on peacekeeping operations. The UN keeps track of numbers of all the different countries. I think the US is ranked 23 or something. Switzerland, maybe 77th in the world in terms of a few dozen people that they actually provide to peace and stability operations. We don't do that. Nobody in the West, either US, Australia, UK, we're not providing troops to do peacekeeping operations. We leave it up to the poorest countries in the world. Over 50% of the peacekeepers today come from South Asia, Bangladesh, India, Nepal, Pakistan. The rest kind of scattered from all the rest of the world. And that's pretty horrifying. The reality is we support peacekeeping operations, but we don't want our own guys on the line. So what happens? Well, if you look down here, IPOA, my own trade association, we're probably 10th in the world in terms of providing personnel to peace and stability operations, just ahead of South Africa, happily. There's no better option. Essentially, if you got rid of the private sector and said you are not allowed to have a for-profit company working in a conflict, post-conflict environment, you would pull the rug out from peacekeeping operations everywhere. IPOA is a not-for-profit company. We're an industry association, we're a trade association, but our goal here is to improve peace operations. We often say we're the middle ground. We have all these NGOs who are Democrats on one side and the companies who generally are Republicans on the other side. We're the middle ground between the tree huggers and the knuckle draggers. And our basic goal here is to try and balance this out. We work for, when we do lobbying, we get our members to lobby one side of an issue. We work with the NGOs and they coordinate the other side of an issue so that we can improve peacekeeping. We can get better funding for peacekeeping, better organization from the government and so on. We have a code of conduct. It's online. I invite everybody to read it and suggest improvements to it. We're on version number 10. But the original version predates IPOA, and it was basically human rights organizations and NGOs that sat down and said, okay, if we're going to work with the private companies in conflict, post-conflict environments, what sort of rules do we want? What are they allowed to do? What are they not allowed to do? So take a look at that, and we're happy to take recommendations and improvements on that. We advocate for better regulations and laws for companies working in CPC environments, and as I brought up before, we support effective regulations and laws that just make sense because the clients are more comfortable, we get more contracts. And we do a lot of advocacy and education. We kind of reach out to schools and so on. Finally, I think we need to realize what our goals are when we talk about regulation and transparency and so on. Our goal here is not to penalize companies that dare to actually provide useful services to peace and stability operations. That shouldn't be the goal. Ultimately, what we want is peace and stability operations that actually succeed. And again, the better you do a peace and stability operation, the more people will be alive in the end, and that's the bottom line. Well, thanks very much, and I look forward to the remaining panelists.
Thanks very much. Another question that you might want to comment on would be to compare the situation of private contractors with the situation when, say, Bangladesh provides personnel to a peacekeeping operation. I've heard, for example, that for Bangladesh it may well be a profit-making proposition, and that it may have a lot of those similar financial implications and questions to be raised. Similarly, with interoperability issues, are the Bangladeshis coming with communications systems, with weaponry and so on, that are in fact going to be integratable with those of other countries, command responsibility, a lot of the same questions. If you would compare and discuss that, I think that would be very helpful. But first, our final speaker, Frank Fountain, who began his 20-year career in the U.S. Army as a communications officer in a tank brigade and then went to law school, after which he served as both defense counsel and prosecutor within the U.S. Army JAG Corps. He later served as legal advisor to the Commander-in-Chief of the U.S. Central Command. While at CENTCOM, Mr. Fountain served as legal advisor to the Commanding General of Operation Provide Relief, which was the U.S. emergency airlift operation into Somalia, served as legal advisor to the UN and U.S. forces commanding generals in Operation Restore Hope in Somalia, and simultaneously as legal advisor to the UN Secretary General's special representative in Somalia. In 1995, Mr. Fountain took up a post at the White House as chief counsel to the President's Foreign Intelligence Advisory Board and the President's Intelligence Oversight Board under President Clinton. In that capacity, he directed investigations on subjects including the CIA's investigation into mishandling of classified information by a former director of Central Intelligence, illicit arms shipments from Iran to Bosnia, U.S. intelligence activities in Guatemala, and security at Department of Energy Nuclear Weapons Lab, the latter, as you know, leading to reorganization of Department of Energy and creation of the National Nuclear Security Administration. Upon retirement from the Army in 1999, Mr. Fountain stayed on in the White House in that capacity as chief counsel to those boards. In 2001, Mr. Fountain moved to the U.S. Senate as senior counsel to the Permanent Subcommittee on Investigations and as foreign policy and homeland security advisor to Senator Susan Collins, who's now the chair of the Senator's Governmental Affairs and Homeland Security Committee. In that position, he directed investigations of national security threats and transnational fraud. After leaving the Senate in 2002, he became the first chief of prosecutions for the United Nations Special Court for Sierra Leone. There he designed and implemented the strategy for the investigation and prosecution of war crimes and crimes against humanity that were committed in the 90s in West Africa in connection with international traffic in illicit arms and diamonds. He was our primary contact for the Duke Law Clinic to support the work of the Office of the Prosecutor for the Special Court for Sierra Leone while he served as Chief of Prosecutions there. And I need to thank Mr. Fountain also for having been very instrumental in getting set up and in place our current Duke Law School Guantanamo Defense Clinic. Upon his return from West Africa, Mr. Fountain served in 2003 as legal advisor to the UN Commission on Human Securities and has since entered private practice in New York, where he provides services to transnational business concerning international transactions, relations with U.S. and foreign governments, and security analyses for foreign investment and activities. Thank you very much and welcome.
I'd like to begin, if I may, with a question, and that is, when does this gathering end?
It ends at 1:30, and we are going over a little bit, but we will, even with your 10-minute presentation, have plenty of time, I think, for a lively discussion.
Thank you. I want to make sure that I'm not going to hold anyone over, and I think that I will be able to stay within the 10-minute limit. Let me also begin with a disclaimer. You heard Professor Morris describe the various positions that I've held in the U.S. government, both in the executive branch, within the military, and in the Congress. And I want to say that nothing I will say here today is in any way necessarily a view of any of those organizations or has any way been attributed to or should be attributed to them. What I'm going to say is what I'm going to say. They're my views and my views only. That said, what I would like to do, and in some ways I think that it's probably a benefit, at least to me, to be able to go last, because I am going to suggest that I'm in agreement with all of the previous speakers and that they are all consistent, and that what we ought to do is to take a step even further than has been described thus far, and that we ought to have a private military force that performs the peacekeeping operations on a global basis. That is, we ought not look to the uniformed forces of nation states to provide this kind of necessary response capability for a global community. I say that for a variety of reasons. First, I believe that the current system, that is one that relies principally on uniformed members of nation states, is fundamentally flawed. It's flawed in at least 4 respects. First, the nation states are reluctant to provide their sons and daughters and treasure to these kinds of operations. That reluctance is understandable, in my view, and in the question and answer session, we could go further into that if you would like. That reluctance has a function of creating a delay in response, which in my view exacerbates the conflagrations that are involved and thus increases the quantity and type of forces that need to be applied to these types of difficulties. The second reason I believe that the current model, that is the uniformed forces of nation states, is fundamentally flawed is that once, however belatedly, the nation states decide to commit forces, the nation states insist upon retaining control over those forces. I think that that retention of control is a natural and expected function and factor. However, I think that it also creates difficulties for the performance of those operations. In particular, it violates a principle of unity of command. It creates, for example, multiple chains of command which require the commanders in the field to return to their national capitals for approval or guidance on military operations. It was evident clearly in the operations in Somalia. It was evident by the nation states represented there. I can provide examples in the question and answer or afterwards for anyone who might be interested in that. But it's, I believe, inherent and inescapable in these kinds of operations because the elected officials who have sent troops into these activities are responsible for their well-being, and thus they want to keep control. In short, there is no such thing as a United Nations Forces commander, except in title only. That commander is nothing more than a conduit who passes on wishes, desires, hopes, aspirations, wild dreams to subordinate nation-state commanders with the hope that they will be satisfied by those national forces. A third flaw is that by sending uniformed forces from nation states, the result is that there are a variety.
Go ahead.
The result is that there are a variety and conflict and mix of organizations that are on the ground, that have boots on the ground, as Professor Silliman put it. There are differences in doctrine, there are differences in communications systems, there are differences in training, there are differences in other forms of equipment, and the result is a hodgepodge, often a conflict of organizations, of thoughts, of equipment types, all undermining the ability of the organization to complete the mission that it has been given. In my view, a solution to these problems is to transfer this kind of activity to a private corporation. Some will recoil at that prospect, but I think that it makes good sense on close analysis. One of the objections to this kind of force is that they are mercenaries, my God. That's not really a persuasive objection in my view, because they are providing the same functions that the uniformed services are providing, and they are, although providing this service for money, for a profit, the profit motive can actually be turned to an advantage in order to instill accountability in the organization that's performing the function. In my observation and in my experiences, the contract model provided the United Nations and other organizations with greater control over subordinate organizations than did the reliance on voluntarily provided forces from nation states. The UN or the other management body can evaluate the performance of a contractor and can impose financial consequences for non-performance or for bad performance, and bad performance can include criminal misconduct or other sorts of misconduct. In addition, the transparency that I believe is necessary can be provided. There is nothing that prohibits the provision of that transparency except the desire of the contractors, in my view, not to have it. There can be clauses that are required by statute. There can be clauses required by the defense acquisition regulations. There can be clauses required by other acquisition regulations, whether by the UN or by other organizations, in order to provide the sort of transparency and accountability that is necessary. I believe that the United Nations or the United States, if it's not in the kind of arrangement that I believe it's in now, where there are disincentives for the government to provide vigorous oversight of the contractors who are currently involved principally in Iraq, but that the United Nations and other oversight mechanisms have the capacity to provide oversight to a better extent than they have the capacity to perform the operations themselves, and that they can be in a position to provide better oversight and control if they are called upon to do that and that only, and not also to perform the underlying missions. With regard to individual responsibility for misconduct, it seems clear to me that there is no legal or other reason why that kind of accountability can not be provided for in the contracts, including perhaps an agreement to be subject to jurisdiction in particular fora for misconduct that the individual actor undertakes or that the organizational actor undertakes. In summary, I believe that a focused examination of greater use of private forces for international policing is well warranted and addresses the shortcomings that are inherent in the current approach, which relies on uniformed members from nation states, and it can deal with and address the challenges that have been described by various speakers and others of the involvement of civilians and contractors in these kinds of operations. I welcome any questions when it's time for that. Thank you.
Thank you very much. Thanks to our panelists. And we have lots of time for questions. I'll just go ahead and orchestrate that. Yes? Please speak up a lot.
As Mr. Fountain was speaking, as all the panelists were speaking, I was thinking, this is a contract-governed relationship. Why don't these contracts involve these jurisdictional clauses? Why aren't they drafted better to ensure a greater degree of accountability? And so I guess my question is, are the contracts badly drafted? Are they just not being enforced? Is there just no incentive other than when journalists finally get involved to actually have the government step in or someone else step in to prosecute anything that goes wrong? I mean, if they are contracts, if there are these provisions, why aren't they being acted upon?
That's a lawyer's question. I have no idea.
I'm not sure it's a question of saying the contracts are badly drafted. I think what we're saying is that this is really a seller's market. And the companies, particularly, and Joe sent me a sanitized version of the Blackwater contract. I was absolutely amazed. It really did, as he described it. It is drafted by the lawyers for Blackwater, but when you're paying someone $600 to $800 per day, they're going to sign it. They're going to sign it. Now, the one thing, as Frank was speaking, if you take this up and basically create a system of a private military force, I'm not sure I'm quite in agreement with him as far as the enforceability of that, because the question is, when you go to that level, who's the arbiter? Particularly when you're dealing with the United Nations. If there's criminal conduct, I can't see the United States ever agreeing to say, well, sure, we'll just let the International Criminal Court deal with this. So you've got a question when you take it above the national level of who decides or resolves disputes and where do you prosecute criminal conduct committed by one of these contractors. So I think there are a lot of significant issues in taking it to the level which he suggests, which I think is a good thing. I think we need to look at that. I'm not sure it's a panacea, though.
Can I ask a question about your last point, which is typically peacekeepers provided by nation states come within the jurisdiction under the status of forces type agreements. Those provided by, we were using the example Bangladesh, come within the criminal jurisdiction of Bangladesh, not of the UN or any international body. Why wouldn't that work?
Because you're talking about military. And the fundamental difference is, again, if you're dealing with military in the United States, there is jurisdiction, and that's used quite often. Matter of fact, whenever we do provide forces to the United Nations for operations, it is with the absolute guarantee that they will be prosecuted, if they're to be prosecuted, under the Uniform Code of Military Justice. And your earlier question, Madeline, after I finish my comments, I do not see any possibility of Congress amending the Uniform Code of Military Justice to allow for criminal jurisdiction over civilians. There are only two provisions right now for civilians to be prosecuted on the UCMJ, Articles 104 and 6, which is spying and aiding the enemy. Those are the only ones that can be prosecuted if you're a civilian. The mood in Congress is to move criminal jurisdiction into the federal courts. And I don't see a retracing of that.
Yeah, I agree. We'll have to discuss it more, because that was not what I was suggesting, but Please.
Yeah, no, I would agree, and I think it was struck down by the Supreme Court, right? So
Yes.
it basically said that there's no way you can try civilians under the criminal court unless war has been declared. But in terms of the drafting of contracts, I mean, it's a good point, and actually the DOD's been sitting down and putting together a boilerplate contract which will address some of the issues that have been raised since the beginning of the Iraq War. The ICC is fine, but there was a recent paper on it by at the Institute of Security Studies in Pretoria. And they sort of said, well, that it's fine, it's a wonderful tool, but when you're talking about peacekeeping, you're not talking about any crimes that are going to rise to the level of war crimes. I mean, it just doesn't happen. There will be smaller crimes. That's what we have to deal with. From an IPOA perspective, we suggested the idea of external courts. I mean, if you can give jurisdiction to, say, Eastern Congo or to Darfur, to a South African court or a Belgian court or something like that, that might be one way to get around these things. And I'll let the lawyers in here say that's completely impossible, but I think there's got to be some sort of degree. The reality is you're sending private companies to operate in an area where there is no legal structure, or one that you don't want to use in the case of Darfur. Essentially, you have a Sudanese legal structure there, but you don't want your peacekeepers operating under Sudanese law for various reasons. So.
We should have a panel on jurisdiction over private forces.
Yeah, my only quick response to that is I know the United States would never say we would allow our servicemen or private citizens acting under a peacekeeping operation to submit to the jurisdiction or be submitted to the jurisdiction of the court. I mean, we're going, as you know, just the opposite, Doug. So, and my guess is the United States is not alone.
And that's fine. And I would point out, I was just in Iraq, and I'll tell you, one of the really interesting things, this is a truly globalized industry. And if they can't use Americans, companies can't use Americans to do these operations, there's plenty of other nationalities to bring.
No, but there are U.S. federal courts, but we should have a broader discussion just on that. Please. Yes.
Some of the arguments for privatizing international peacekeeping make sense to me. They seem logical. I don't see why those arguments couldn't be extended to privatizing national militaries for exactly the same reasons that were outlined. Sometimes when countries go to war, I think we can think of recent examples. The entire country doesn't seem to want to go to war, but some people do. Sometimes, the political cost might be much less. Why not privatize national militaries as well? I mean, I don't see any reason why the same arguments do not apply. I don't think because the way in which international peacekeeping was justified was to say that this was in the global interest, just as when a nation goes to war, it's supposed to be in the national interest. So to the extent that there's an international system, I don't think the justification for international peacekeeping is fundamentally different from that of a country going to war to defend its interests. The idea there is that the globe's peace is at stake, and to the extent that countries join the UN and have bilateral agreements, that's how they raise a force to do peacekeeping. So could you comment on the implications of national militaries being privatized too, and why not, if not?
May I assume that the U is directed to me? One observation I would make is that many have said that that is already occurring, at least within the United States, and that the all-volunteer force is, in effect, a type of privatized national army for the United States. And I've happened to find some considerable merit in that proposition. Would welcome the opportunity to discuss it at another time. I think that there is some advantage in a privatized national military force. There are disadvantages as well, and there are, I believe, ways to identify what those advantages and disadvantages are, and ways to attempt to articulate them in a rational way. But I don't think we have the time to do that today.
I would feel nervous about about not having a stronger military than the private force we were using. I mean, I assume that that's one of the most fundamental
That's
parts
one of
it.
the concerns.
Mr. Brooks, I guess my question is, you seem to have spoken well that private organizations doing international peacekeeping is not an inherent evil. There are many advantages, but I guess what is being done to address some of the disadvantages that Professor Silliman spoke about, say, with the interoperability or the chains of command, and not, or I'm sorry, what's the reporter? What's your name, sir?
Joe Neff.
I'm sorry, what?
Neff.
Neff. Mr. Neff talked about just not knowing what's going on with the costs. What's being done to, I guess, say costs and problems with chain of command. What's being done to address those things?
Well, in terms of interoperability, you already have that with the UN. I mean, it's not poor man's NATO. NATO being the largest military alliance where everybody uses the same equipment, the same ammunition, same radios, things like that. When the UN does an operation, it brings in a whole bunch of different militaries, a whole bunch of different equipment. Your truck tires from a Pakistani truck will not fit onto a Malaysian truck, this sort of thing. So it's a huge mess. So interoperability, or the lack of, is already there. The private companies tend to be far more organized, actually, and they have to work with their clients, so the militaries and so on. Chains of command, I think, well, actually, if we go back to the Fallujah issue, the fact that the military didn't know that these contractors were passing through Fallujah. Think about it this way. What if those guys had been with the New York Times or with Joe's newspaper? What if there'd been 4 Americans from wherever, researchers, who knows, who were killed? The same thing would have happened. It wasn't because these guys were security contractors, it's because they were Americans that this happened. Now, the combatant commander is seldom going to know where all citizens of all nations are in these sorts of operations. Now, what happened after Fallujah, and something that sped up the process, was they set up a regional operations center. They set up a system which includes some software called Tapestry, which tracks all the civilian PSD teams, personal security detail teams, all the convoys and so on. They're all tracked by GPS. It's very, very interesting. And the military can see all their convoys and can also see all the civilian convoys. So what happened there isn't going to happen again. But it was a learning process. Everybody had to figure out how these things worked. In some sectors in Iraq at that time, everybody knew everybody. All the private guys knew all the military guys, and it was very coordinated. Yeah, but when you're doing traveling across the country, then that's where the problems happen, because nobody knew exactly who was doing what and so on. So, I mean, it's in any process, whether it's in Congo or whether it's going to be Iraq, these interoperabilities, communications, chains of command have to be worked out, and they're all going to be different. You can't just create one system that's always going to work. I think we've learned a lot of lessons from Iraq, but I think we also have to keep in mind that Iraq was very unique, and we're not going to see that in the future. But, it does bring up some ideas that we might be able to use.
Let's see, we're not going to have time for everyone.
Actually, I'm afraid, Madeline, my class is supposed to start now.
Oh, I thought we had the room until 1:25.
Sorry.
Well then, nobody, that's fair. Thank you, panelists. Thank you, that was really great.